Hey y'all, and we back with another reaction. A federal judge has rejected former President Donald Trump's request to strike references to the violence at the Capitol on January 6, 2021 from his federal election interference indictment in a case that is set to go to trial in just over 3 months. Trump sought to have certain passengers struck from the indictment, which was returned in August on grounds that they would inflame the jury and create bias against him, even though he has not been charged with any crimes of violence. But U.S. District Judge Tanya Chutkan wrote in the order Friday that there was no risk of the indictment creating bias from the jury because they would not be getting a copy of the actual indictment to refer to during deliberations. The jury selection process will be able to weed out any credentials jurors who have already read the indictment and been exposed to the references to violence since she added, regardless whether the allegation and the issue are relevant. Uh, Defendant has not satisfied his burden to clear, clearly show that they are prejudicial, prejudicial. Um, Chutkan wrote. Prejudicial, y'all. Trump's motion, she wrote, makes numerous inflammation and unsupported accusation and devote only a single paragraph to the prejudice requirement, in which the former president claims the jury pool has been exposed to the indictment is inflammatory and prejudicial allegation through media coverage relating to the case. But Trump's motion fails to cite even one example of that evidence, she wrote. In any event, the Volda process will allow the court to examine and address and affect the pretrial publicity, including any generated by defendant, has had on the impartial potential jury. Chutkan wrote. When jury began to, the court will also take steps to screen from the jury and irrelevant and prejudicial material that either party seeks to introduce moreover before the jury deliberate. The court will instruct them on the actual charges and the evidence they may consider in their deliberations. Okay. Thanks for watching. I got a video I want to show y'all. I always got a video for visual people who are visual. Okay.
This is the first time we have heard from federal judge Tanya Chutkan, and she has said some really interesting things, telling Trump's lawyers that the administration of justice comes first, and that he may not be able to say everything that he wants to in political speeches.
It is Caitlin Poland outside the court for us once again. More and more details, Caitlin. If you can, bring us all up to speed once again on what we have may make. The judge here has been quite clear, saying that his speech is able to be limited. The First Amendment does have limitations to it, and that she is not going to be doing things based on what is happening in the political sphere. She is a judge, it is separate. One of the quotes that really jumps out from this hearing today, the fact that he is running a political campaign currently has to yield to the administration of justice. And if that means he can't say exactly what he wants to say in a political speech, that is just how it's going to have to be. And then also she says, I cannot and I will not factor into my decision what effect it will have on a political campaign for either side. And so there are still many arguments being made here, and they're talking about how Trump will be able to disclose or not disclose, largely not disclose, information he's learning as he's getting evidence, and his lawyers are getting evidence in this case, and they prepare for trial. But also, Judge Chutkan is clearly issuing quite a warning to Trump and his defense team that he needs to be careful not to obstruct justices, not to intimidate witnesses, and that is a real thing, a real line that he could cross if he keeps talking publicly about witnesses in this case. She's really tried to avoid it being specifically about any witness in particular. His lawyers have brought up Mike Pence. That's something the Justice Department also had flagged here. But this is quite a clear sign from the judge. And on top of that, they're still working out some details in this situation, how much Trump can review evidence, where he can review evidence, who can be with him, also how they will designate the evidence in this case as it gets handed over. What are the things that Trump specifically can't share more widely versus what can he incorporate into his political speech. But so far, this is quite a set of things that the judge has said, really taking on a lot more than just the legal issues in this case, which I might note have largely been in line with what Donald Trump's lawyers have agreed to or have proposed so far.
All right, Caleb Poland, don't go far, because we keep getting new reports from inside the courtroom. For stand by, if you will, for just a moment.
So Paula Reed, who's been inside the courtroom, she's making her way out, so we're going to be able to hear from Paula what she saw and heard inside the courtroom as well. In the meantime, joining us right now is former Assistant U.S. Attorney Nick Ackerman for more on this. Nick, Kaylin has been laying all of this out for us, what has been coming out from court, what the judge has been talking about. Just before we jump into some of her quotes and things we've heard from the judge, overall, what do you take from what we're hearing from the judge so far?
None of this is.
What? I want to hear this. I'm sorry. I got to hear this. None of this. What? I want to hear this. None of this. What? Because the judge ain't playing. Oh, sorry.
None of this is very surprising. This is a very standard protective order that the government wants. The purpose of a protective order is for the defendant to be able to get discovery and use it for his defense, not to put on a public display or contest the allegations in a public forum. He's already agreed to two protective orders that are almost exactly the same in both the Miami classified documents case and the New York case prosecution. So none of this is surprising. I think she's essentially going to be putting in place the order that the government has asked for. And based on the comments that I heard, it just reaffirms my opinion that this case is going to trial in January or February of next year. This judge is not taking any blowback from this defendant. They've tried over the last couple of days, if you look at the filings that have been made, they've tried everything to delay this as much as possible, put this over until next week, try not to make it very important in a manner that's pretty perfunctory. So I think the judge has seen through their delay tactics, and she's not going to take any of it. And I think this is a clear message to Donald Trump that he is going to be in the dock in January or February, and the jury is going to be listening to the evidence.
The actual legal rulings,
Okay, y'all. I'm gonna stop it right there. I don't want to give y'all all this information. Y'all. Like, share, and subscribe. And Donald Trump will not be able to freedom to spear, to just say anything he want to say, dealing with Judge. Let me make sure I pronounce the name right. Let me make sure with Judge Chutkan. Yes. Okay. Um, Trump election interference case won't strike January the 6th. Okay, she is not playing. Y'all like, share, and subscribe, and leave your reaction over here in the reaction chat. Okay, I'm out, y'all.